Hi, everyone. As Adam said, I'm Laurel Felton. I'm from SARM. I'm the Director of Programs and Operations, and I'm here today to just introduce our webinar speaker. So this is the Municipal Leaders Roles and Responsibilities webinar, and Judy Kanak, Municipal Advisor from Advisory Services at the Ministry of Government Relations, is joining us today to deliver this webinar. Judy's presentation is going to provide information to both newly elected council members and even for those that have been councillors for a long time would likely find it valuable. She'll be speaking on things like code of ethics, conflict of interest, council procedures, and more. So welcome, Judy, and thank you for the presentation today.
Thank you very much. Good morning, everybody, and thank you, Adam and Laurel, for inviting me to participate in this Module 1 of your Municipal Leadership Development Program. And as Laurel mentioned, this module is called Municipal Roles and Responsibilities. And I'd also like to say congratulations to all of the newly elected council members that are participating in this webinar today. I'm pretty sure you're going to find your next 4 years in office. I almost said hours there. You're going to find them very, very interesting, very, very challenging, and very rewarding as well. Next slide, please. So here is a general overview of what we're going to cover during this presentation, which Adam mentioned at the end will be followed by a question and answer period. So you can see there is a lot of information that we're going to cover, and really we're just going to cover the high points of the things you need to know as a municipal council member. It's really impossible to cover everything you need to know in the short amount of time that we have, but hopefully it'll give you an idea of what you need to know, and of course you can look into it further on your own time and using any other resources that are available to you. And please know that yes, there are many, many resources available to you out there through various organizations, and on our website you can find all kinds of information. Our office is also here to help you with questions. Next slide. All right, here are the top 4 things that I hope you remember throughout your 4-year term in office. So number 1, municipalities are a level of government, which means they have a considerable amount of independence to govern within their jurisdiction. And by jurisdiction, I mean legislation. So the Municipalities Act, as well as other pieces of legislation, will explain what your jurisdiction is, and the legislation also anticipates that municipalities will act as responsible levels of government, as any level of government should. The provincial government has very, very limited authority to intervene in local government affairs. Now, I know that many, if not all of you, have heard of some instances in the media about some cases where the provincial government has intervened, but those are very extraordinary cases. And I don't think your municipality really wants to get to that point of notoriety. Number 2, councils are required to conduct their business in an open and transparent manner. Your council meetings can be attended by the public anytime, and even during COVID-19. The public that elected you has a right to know what their government is doing, and council is accountable to the public because of our democratic electoral process. All right, I just see that there are some questions popping up on the screen, so just getting used to a different platform using with Adobe Connect here today. All right, so there are a few exceptions to the open and transparent rules, such as the ability for councils to hold closed meetings. Councils also have the duty to respect privacy laws, but we are going to get into that a little bit further into the presentation. Number 3 on the top 4 things to remember is that council members are part of a team. No individual council member including the reeve, has the authority to make decisions alone. Each council member is just one member of a team, which means the team has to collectively work together to make decisions that is beneficial to the entire municipality. And number 4, resolution, resolution, resolution. Please remember that. This is the only way that decisions can be made. The only way resolutions can be made is if there is a duly called council meeting. All right, next slide, please. So I'd like to share this graphic with you because I think it's really, really important to understand that trust is the foundation of any effective relationship, including the relationship that council has with their ratepayers. If council members understand how trust works, then you're going to have a successful term in office, and you'll have a respected team. So everyone starts with a stranger level of trust, which is represented by the horizontal line in this graphic. As you get to know a person, that trust builds. You'll see that on the left side where it's starting to go uphill. If that trust is broken by whatever reason, whether it's a decision of council or an action that is taken, don't assume that trust is going to automatically return to the stranger level of trust or the horizontal line, because in fact, it does not. Because of the time and effort put into building that trust in the first place, when it's broken, it drops below the stranger level of trust. In fact, very often far below. So now you would have to start rebuilding that trust. And it takes a lot longer than the substantial or the initial building of trust. This is because when it drops below the stranger level of trust, people are often very hesitant to give other people the benefit of the doubt. So this concept also relates well to the relationship council has with the public. It demonstrates how important the public's trust is in their local government's leadership. Next slide. So let's look at what the purpose of a municipality is. First of all, good government, which means making decisions that affect everybody in the municipality. People want services and facilities. So it's part of your job as a council member to determine what is needed versus what is wanted, and then figuring out how to resource those services and facilities. People want communities that are safe, obviously. And of course, you'll want a municipality that is viable beyond just your term of office. And lastly, a municipality has a responsibility to safeguard its infrastructure and its public assets. Next. Sorry, I have to keep saying that. I'm not advancing the slides. Adam is doing that for me. All right, so as mentioned earlier, it's the Municipalities Act that is the legislation providing the framework for municipalities to govern. There are other pieces of legislation used as well during the operation of any municipality. In the Municipalities Act, you'll see two words that are frequently used, that's shall and may. So the things that a municipality shall do are your duties. For example, municipalities shall conduct their meetings in public, or they shall and must provide public notice before they discuss certain matters. When you see the word shall, that's an obligation. It is required and you must do it. The word may is also used extensively throughout the legislation, and that means a municipality or a council may decide or can choose to decide whether or not to do something. It is their choice. Whatever your council decides, be prepared to justify your decisions, because if people ask why you made that decision, you should be able to give them an answer. There is an expectation in legislation and from the public that everyone will be treated fairly. And there's also a risk that not everyone is going to like it. Next slide, please. So this slide goes just a little bit deeper into the original top 4 things to remember. Municipalities are required to act through council, which means council must pass resolutions or policies or bylaws, and all of those things are passed at a duly called meeting. And to call a meeting or to hold a council meeting, there must be appropriate public notice given. There must be a quorum of council present, and the administrator must attend. So it is not acceptable to make a decision by a text message or by email. Using emails and text messages actually take away the public's right to participate in their municipal government, which accordingly is not demonstrating openness and transparency. Decisions can only be made by resolutions. If there is a decision that needs to be made on short notice, it's probably best to quickly call a special meeting, which can be done on pretty short notice. Or, if possible, even wait until the next regularly scheduled meeting. Oftentimes, texts or email messages are referring to operational matters. So there's also the ability for council to set some policy whereby their administrator has the right to make decisions on certain operational matters. Next slide. So, what is an oath or affirmation of office? This is a prescribed form that you should have all signed prior to your first meeting. So many of you will have already done this. Prescribed means using the specific form that is provided in the legislation. In this case, it's found in the municipality's regulations. So any member of council who refuses to sign this oath or affirmation of office has no right to participate in any council matters, any council meetings, or any council decisions. Next slide. So let's discuss the public disclosure statement, something else you should already have been familiar with. Now, this form is not prescribed in legislation, but legislation says that it's mandatory for all candidates running for office and all elected council members to complete. It contains some certain information about a council member's employment, their financial interests, business interests, and property holdings. But as you already know, there's no dollar values attached to that. Council members must keep this document current. So annually, they're required to submit a declaration, either stating that nothing has changed since the last time a public disclosure statement or an amendment was filed, or make the required changes. They're also required to report any changes as they occur. So as soon as you know something is different, fill out an amendment form and file it with your administrator. This public disclosure statement is a public document, which means anybody can see it anytime they choose. And as you may have guessed, it's got a direct impact when dealing with a conflict of interest. Next slide, please. Conflict of interest is an essential part of legislation, and all council members need to be very, very mindful of it. A council member has a conflict of interest in a matter before council that will further his or her private interests or those of another person. Interest can mean financial interest, or it can mean personal interest. But keep in mind that a financial interest is always a conflict of interest. Please also know that when there is a financial interest involved, it doesn't matter how much money is involved. So $10 or $10,000 doesn't matter. As long as it's financial, there's a conflict of interest and it should be handled properly. So that being said, it's okay to have a conflict of interest. In fact, there's a very, very high possibility that most council members will eventually have a conflict of interest at some point in time during their years in office. In fact, it's even more likely to occur in smaller communities where there's a pool of smaller potential contractors and employees. Everybody knows everybody, so it's much more likely to occur. But what's really important is how a council member handles a conflict of interest. Next slide. So council members are individually responsible for declaring a conflict of interest that they might have. This is an ethical duty essential to good governance. It is not the responsibility of your fellow council members to decide or monitor or police your conflict of interest, and neither is it the responsibility of your staff. As we mentioned earlier, every council member has to swear or affirm by signing their oath that conflicts of interest will be declared or disclosed. We're often asked in our office how a council member can be forced to declare a conflict of interest that they may have. And really, the short answer, you can't. However, there are some steps that you can take to encourage appropriate behavior by your fellow council members. For example, you could informally identify the concern by simply asking the other council member verbally if perhaps the matter that is before council for discussion just might be a conflict of interest for them. Or you could formally raise the concern by filing a complaint under your Code of Ethics bylaw. You could also request a recorded vote at the meeting. So requesting a recorded vote has to happen before the vote is actually taken. That vote or recorded vote is then declared or recorded in your minutes, and anybody reading the minutes will instantly see whether a person with a conflict of interest declared their conflict of interest and left the room, or if they stayed and participated in the decision making. And of course, another option is always using the law courts. Hopefully, in most cases, you don't have to do that. So it's relatively easy to handle a conflict of interest. It's just being aware of what those steps are. So when a matter comes before council that you believe you have a conflict of interest in, or you think you might have a conflict of interest, here are the steps that you need to follow. Number one, declare, which simply means declaring that you have a conflict of interest in the matter. Number two is to disclose, meaning you will disclose just in general terms what your conflict of interest relates to. Number three is to abstain, and that means abstaining from any voting. Number four, refrain, means to refrain from having any discussion in the matter, and that means before, during, and after. And finally, number five is leave, which simply means after you've declared, disclosed, abstained, refrained, just leave the room and don't return to council chambers until the matter has been completed by council. So I put at the bottom of the slide an asterisk beside Ombudsman Saskatchewan. If you were to visit their website, you will find all kinds of very, very good information about conflict of interest as it relates to municipal council members. They have pamphlets and brochures, and I think they're great for council members to refer to. Next slide, please. All right, your municipality shall have a code of ethics bylaw for elected officials. This code of ethics bylaw defines how you are to treat staff, other council members, and of course, the public. It talks about honesty, which means council members must be truthful and open. It talks about objectivity, which means decisions have to be made carefully, fairly, and impartially. The code of ethics talks about respect, meaning providing respect for everyone, including council members, staff. Everyone deserves to be treated with dignity, understanding, and respect. It talks about transparency and accountability. So council business should be conducted so that citizens are able to clearly see how and why a decision was made by council, and perhaps what information or advice or consultation they used in arriving at any decision. It talks about confidentiality. So as a council member, there may be times where you are privy to confidential or personal information, and you have a duty as an elected member of council to keep that information confidential and not share it with anybody. You are not to benefit personally by any information that you happen to learn during the course of your term in office. The Code of Ethics bylaw will also talk about leadership and public interest, which means that you will serve your citizens and act in their best interests or the best interests of the entire municipality. Personal benefit, wrongdoing, or unethical conduct will simply not be tolerated. Your Code of Ethics also talks about responsibility, which means you have a responsibility to act in accordance with the law, which is the legislation giving you that framework under which to operate. It also means that you have a responsibility to disclose all conflicts of interest and follow any policies or procedures that your council, your municipality has decided to adopt. The Code of Ethics bylaw also will have within it a process for dealing with any contraventions or breaches to the Code of Ethics. It will also include possible remedial actions. So when somebody does violate the Code of Ethics, some possible remedial actions that council could consider to impose on those council members would be maybe something as simple as a written or a verbal apology, or maybe the requirement to take some training. The training could be on ethical conduct, respectful conduct, or maybe even anger management for that matter. Another possibility would be removing a council member from any committees that they perhaps sit on representing the rural municipality. Or perhaps tasering. No, not really. A colleague of mine said that I should put tasering in there, but I said, no, that just simply wouldn't be right. So no, you cannot use tasering as a possible remedial action for your council member. So if you haven't already noticed, there is a close relationship about the recent topics that we've already covered. So oath of office, public disclosure statement, conflict of interest, and code of ethics. It's all about being open and transparent. And I can't stress enough how important those items are, because most of the phone calls that we receive from public and council members usually has to do with the subject of any one of those things. Next slide, please. Okay, so this slide shows an example of what your municipality's organizational structure might look like. So in legislation, except for stating that council is accountable to the voters and that council must appoint an administrator, it does not describe how your municipality is set up. But the key thing here to remember is communication between the different roles in the organizational structure. When everyone understands their role, your municipality is much more likely to function properly and smoothly and successfully. When we hear of municipalities having trouble either with their staff or with the public, it's usually because of a weakness in this organizational structure. So the lesson here is, please respect everybody's role in your organization. Next slide, please. We'll go into some of the individual roles that are on that organizational chart. So first of all, the voters or the public. Municipalities are accountable to their public, and the public has certain rights. They have the right to observe council meetings. They have the right to access certain municipal documents, not all, but in legislation there is a list of some documents that anybody can ask to look at or get a copy of, basically anytime. So some examples that are on the slide, you can see minutes or bylaws, for example. The public also has the right to interact with their council members, either formally, which would be at a council meeting as a delegate, or informally, maybe over coffee. The public also has the right to petition their council for and against bylaws, resolutions, perhaps policies. They can petition for a public meeting of the voters. They can also petition to have a referendum and also certain special audits. We have a publication in our ministry called Citizens Guide to Shaping Council Decisions. This document we use often, particularly with the public when they call us. We will email it to them, we will mail it to them, or we'll point them in the right direction to our website where they can download it themselves, just to give them a better idea of what their rights are as a voter or a public person in their municipality and what their rights are. We also encourage administrators to have copies of this publication in their office so that anybody can pick one up if they want. Next slide, please. So the role of the elected officials, or you council members, your role includes the following general duties of council members. As a council member, you must represent the public in their best interests. You're expected to participate in developing policies, programs, and services. You shall participate in meetings. Elected officials should ensure that there are administrative practices and procedures in place. Council members must keep private matters confidential. And they must maintain the municipality's financial integrity. So what about the duties of the Reeve? Well, in fact, the Reeve's duties are very, very limited. They, of course, have the same general duties as every other council member, but in addition to those general duties, the Reeve has a couple of additional duties, but not many. The Reeve must chair all council meetings. The Reeve has the ability alone to call special council meetings, and the Reeve is the head, as defined under the Local Authority Freedom of Information and Protection of Privacy Act. And because that's such a long title, we like to use acronyms and abbreviate things, so we call it LaFoIP for short, and we might also refer to it as the privacy legislation. Now this slide's actually missing, I believe, one very, very important duty. Elected officials should not involve themselves in the day-to-day operations of the municipality. As you know, council members cannot be employees of a municipality, nor can they act as an employee. So just remember that council members are decision makers, they are policy makers, but they certainly are not action takers. Leave that to your staff. Leave the operations to your staff. That is their role. It is not council members' role. So that's another important reason to have an organizational chart for your municipality. Okay, let's move on to the next slide, please. We'll talk a bit about the administrator. So legislation requires every municipality to appoint a person to the office of administrator, and that administrator must be certified. There is a rural board of examiners that determines what the qualifications are for administrators to become certified. On the slide, you will see that administrators have multiple accountabilities to various groups and organizations and people. Next slide, please. All right, so your municipality might need to provide notice to the public before they discuss certain matters. Some of the instances or matters that council is planning to discuss that does require public notice in advance are such things as special council meetings or rescheduled regular meetings. Every time council decides to set or revisit their remuneration, there has to be public notice given in advance of that. Public notice has to be given before borrowing money or before permanently closing a road. There are many, many other instances as well that public notice is required, but you do have what's called a public notice bylaw, and it outlines all the various things that public notice is required for. Alrighty, let's go on to the next slide, please. So council procedures bylaw. Your council has adopted in the past council procedures bylaw, and this is going to guide your municipality's procedures at meetings. It is a very large, comprehensive, long bylaw. It has lots and lots of information in it, including just a few examples that are shown on the slide. All council members should be very, very familiar with this bylaw. In fact, it should be readily available at every council meeting, just in case something comes up where you're unsure of the process in handling that type of matter. So as the slide states, this bylaw is mandatory for all municipalities to have. And the importance of that is if you do not have a council procedures bylaw, your municipal revenue sharing grant could be withheld. And I don't think anybody wants to lose any of that money that is coming their way through the municipal revenue sharing grant. So make sure you have the council procedures bylaw in place. All right, next slide, please. So with certain exceptions, all council meetings are open to the public, which I briefly mentioned earlier. That means anybody, not just your ratepayers. The public is anybody. I could come and sit at your council meeting just to watch and observe, just like anybody else out there could. The reason for that is people have the right to watch their government in action. Now, the public are also expected to behave when they're in the council meetings. Your public or your council procedures bylaw is going to outline how the public is expected to behave at the meetings. Now, that being said, there's also, because meetings are public, even if you don't have anybody attending to watch and observe your meetings, anything that's discussed in your council meetings can also be discussed outside the council meetings. It's public information. There could have been somebody there watching and listening. So this relates back to the earlier slides about the top 4 things to remember about being open and transparent, and the trust graphic that we looked at earlier as well. So the more open and transparent that your council is, the fewer problems you are going to have with public trust. Now, if the public wishes to address council and talk to council, they can simply speak to the administrator and ask to be put on the agenda as a delegate, and that gives them the right to address council directly. Some municipalities have annual ratepayers meetings. These meetings are for exchanging information only. They're not for deciding about municipal matters. They're not required by legislation, but they really are a good tool for public relations. A lot of rural municipalities tend to use them as opposed to urban municipalities. So this would also be a good time to discuss the interaction between council members at a council meeting. People who disagree are not necessarily in conflict. In fact, debate is healthy. Debate often leads to great decisions. Council members should communicate clearly and openly. They should provide input, but also respect the input of other council members. They should focus on the facts and confront conflict early instead of allowing it to snowball and fester. So if council meetings are open to the public, how do municipalities accommodate that during this COVID-19 pandemic? Well, really, thank goodness for technology, because that has made it relatively easy to still be able to continue operations for a municipality and involve your public. So even if you don't typically have the public attend your meetings, you have to make provisions for the public's ability to attend. They have the right, remember, to watch and to listen, or to at least listen to the proceedings that are happening at your council meeting. And as you know, there are multiple ways to do this, even if you don't have a good internet connection. Some examples would be maybe moving your meeting to a larger location where you can accommodate physical distancing. You could use telephone conference calls. Some municipalities are live streaming their council meetings to social media. And of course, there are many, many video conferencing platforms out on the market today, which have become very popular since COVID-19 has started. So some examples of those would be Zoom, WebEx, or Skype, and of course the one we're using today, Adobe Connect. It takes a little practice to get comfortable with it. I get that, but every time you use it, it gets a little bit easier. So don't be scared of learning that new technology. It also has actually a lot of benefits, and some council members that we're hearing from actually really like it, because there's the benefit of allowing anybody to join from anywhere, including, say, for example, the snowbirds that go south. They can still participate in their council meetings when they're away from home. And what about the time saving of not having to travel to and from the meetings? So that saves time for anybody joining electronically. The only thing is, whatever platform or whatever means you decide to use to still engage your public, remember you have to also follow any public health orders that might be in place at the time. All right, next slide, please. All right, so this leads us to closed sessions. Often we call them in-camera sessions. Council has the ability to close all or even just a portion of their meetings to the public. But please be very careful how you use them. And use them very sparingly. Closed meetings can lead to a lot of assumptions from ratepayers, including suspicions of secrecy. This does not improve any building of trust that you may be working on. And while confidentiality is important to good governance, secrecy will definitely weaken it. So that being said, sometimes there are sensitive matters that must be deliberated by council in a closed session. Because council has a duty to protect personal information or private information, some examples of that might be staff hiring, or perhaps staff performance evaluations, perhaps handling a code of ethics complaint. That must be done in a closed session of council. Or if you're involved in any legal issues, your municipality, then you should also go into a closed session to discuss those. Next slide, please. I mentioned at the very beginning of this presentation that there are many resources available out there. These resources are designed for anybody, for council members, and for your administration staff. So first, there's the Municipal Peer Network. This connects municipal officials and administrators with highly experienced mentors. It can provide advice and help resolve disputes. The mentors are trained in coaching, communication, facilitation, and dispute resolution. It can be reached by phone or met in person. All conversations are confidential, and they're also free of charge. If you visit the website for the Saskatchewan Municipal Peer Network, you will find contact information for all the various mentors that are participating in this program. Then we have the 10-minute trainers. That's a free online training tool that helps expand the knowledge of counselors and administrators. Each module includes a short video and questions designed to engage the entire council in discussions. There are 2 videos, one about the council procedures bylaw and one about roles and responsibilities of both council members and the administrator. So they can be found on the province's website as well. Now, please be warned, the province's website is quite large. So if you want to get to the right page, sometimes it's hard to find it, but I've put there in brackets under the 10 minutes trainer. If you go to government, once you're at saskatchewan.ca, then select government and then municipal administration. Once you're at the municipal administration page, that would be a real good point to insert a bookmark so that you can reference it quickly and easily in the future. There's also a search feature on the ministry's or the province's website. If you know the name of a document or maybe a matter that you want to find out more information about, just try typing that into the search bar, and there's a good chance you'll be able to find it that way as well. Also, on the province's website, you will find a large selection of various guides and fact sheets, manuals, and of course, general information about a lot of different items. So some of those items are a municipal council member's handbook. Perhaps your administrator prepares an orientation package to give to newly elected council members and put that handbook in that package. So maybe you're already familiar with that. Also on the website, you'll find information about conflict of interest and public disclosure statements. There's a lot of information about community planning. And of course, various recorded webinars that you can access as well. And of course, don't forget to check out your association's website. There is a lot of information for municipalities on there as well. Next slide, please. So the Ombudsman Saskatchewan, they take complaints about municipal entities. They have resources available on their website that may be helpful to you in understanding what the role of the Ombudsman is and for making and communicating decisions fairly. The Office of the Saskatchewan Information and Privacy Commissioner, another long title, so we'll say OIPC for short. They oversee 3 Saskatchewan statutes, including LaFoIP, or the privacy legislation that I mentioned earlier. It ensures that public bodies respect privacy and access rights that citizens have. By informing the public and resolving disputes, they will investigate complaints and issue recommendations. They also have some training sessions available. And the last one on that slide, Publications Saskatchewan, that website houses every and all publications that is created by every and all government ministry and agency. It also includes legislation. So if you're ever wanting to have a look at any particular act or regulation that's in place, that's a place where you can find it. Huge website. Again, I would recommend using the search feature in there, and you'll be able to find perhaps what you're looking for a lot quicker. Next slide. And finally, our office. This is our contact information. We are here to help elected officials, plus administrators and the public, and we will help provide technical advice about municipal government. All right, that brings me to the end of the slide presentation, and I think we're going to be moving into question and answers. Hopefully I can answer most of your questions, but I guess I'll say now, if I am unable to, because I may have to research some questions, by all means, I can get back to you, or you can contact our office and we'll certainly help you out.
Thank you very much, Judy. That was a great presentation. This is the Q&A portion of the webinar. So I am new to this. I'm just looking to see, we have some Q&As in the box here. I'm just going to see if we have any that I can direct to Judy. Hold on one second. One, Laura Lee Peterson asks, is it possible to get an e-copy of the PowerPoint presentation? I think Adam has addressed that further down, but yes, we will be making it available for people to view, so that will be taken care of. Jessica Davis has a question, Judy, and it says, can a conflict of interest be if a council has bad feelings towards a certain local company it would not want any work to go to that company. So would that define a conflict of interest?
Okay, well, remember, it's up to an individual council member to make that determination if they think that they have a conflict of interest, or perhaps they've even got a bias in making a decision. So they can certainly decide to excuse themselves and not participate in that particular conflict or that particular matter when it's being discussed. So it's up to the individual council member. They have to decide for themselves.
Okay, hopefully that helps Jessica. I have a follow-up question from Jessica. Is there a list of possible remedial actions we can take when a complaint has been made against the Code of Ethics?
Your Code of Ethics bylaw already should have a list of remedial actions within it. Now, just ask your administrator for a copy of your Code of Ethics bylaw and have a look at it. In the process for handling a code of ethics, you'll find a clause in there that talks about possible remedial actions that your particular municipality has decided to adopt. And those can be different for every municipality. It just depends on what your council has decided to use.
Okay, thank you, Judy. Next question. Can the public petition to remove a councillor?
No, they cannot do that. They would have to wait until the next general election for that particular office. Those people used our democratic electoral process to put that person in to that office to begin with. And it's up to the public to vote them out during an electoral process as well.
Okay, thank you, Judy. Next question. What happens if there is a conflict of interest with the administrator?
Well, that individual council member must declare that conflict of interest. If you remember the 5 steps, declare, disclose, abstain, refrain, and leave. If there is a conflict of interest between a council member and the administrator, then absolutely they should be declaring it anytime a matter comes up where there's going to be discussions about the administrator. Just follow those steps, declare that you have it, and disclose why you have a conflict of interest. So I'm just trying to think of some instances. I suppose there could be a relationship, a family relationship between a council member and an administrator. So in that case, absolutely, there should be a declaration of a conflict of interest before maybe there's a performance evaluation review happening with the administrator. So very good idea to remove yourself from that type of a situation.
Okay, thanks, Judy. Next question is kind of related to that one you just went through, but Kirk had actually asked if you could provide some additional comments on conflict of interest examples that fall outside of financial interest. And you just mentioned one where maybe there's a personal relationship or they're related somehow. I don't know, did you have any other examples you could share?
Sure, I can think of, let's say, for example, a council member's spouse works someplace. On the public disclosure statement, you're going to record who the employer for your spouse is. So if your municipality happens to do business with that employer of your spouse, then anytime you have a matter come before council that is going to be involving that employer, you should be declaring a conflict of interest because, of course, your spouse works for that particular business.
Thank you very much. I hope that helps. Next question is from Roxanne. Do all councillors, new and returning, have to sign the oath of affirmation? So new, she understands, yes. Returning is the question, I guess. Do they have to sign an oath of affirmation when returning?
So by returning, I think you mean people who have started a second term. So they did 4 years, and this year they were re-elected again to do another 4-year term. And yes, absolutely. It's like they're starting all over again. They're starting a brand new term of office for another 4 years. They do, in fact, have to sign that oath or affirmation of office.
Okay, thank you very much. Next question. So Chrissy asks, so if you have council members wanting to leave a meeting because they think it's a conflict, and then you find out that they spoke about more than they were supposed to, is there anything you can do? After the fact, I think she's
after the
meaning.
fact. So I'm assuming that you're, by anything you can do, you being another council member, well, yes, you can. Now, again, you can confront that individual and make it known to them that you believe they had a conflict of interest in a matter. You could file a formal complaint against that person having a conflict of interest. There is I don't know how familiar most of you would be with the legislation, but you certainly have the ability to look it up or ask your administrator for further information. But in the legislation, the Municipalities Act, sections 147 and 148 specifically talks about disqualification of council members and what the reasons are that they may be disqualified for. One of the reasons is not declaring a conflict of interest. Now, another council member or even council, or in fact the public, could decide to make application to the courts and have that person, I guess, removed from council, but it's up to a judge to decide that. There is also an ability for council to declare a council member's seat vacant if they happen to be disqualified for any of the reasons mentioned in section 147. If a judge decides that a council member is in fact disqualified, they would be removed from council and wouldn't be able to sit on any council, not just that one, but any council for up to 12 years. So it can get quite serious, and there are, like I said, different ways to do it, but be careful. Make sure you do all of the research and investigation before you take action on such a serious matter.
Oh, okay. Sorry, Judy. Chrissy has sent me another note here about her question. I just want to clarify.
All right.
So she was the one with the conflict. So she left and found out they spoke, meaning council, I would assume, about more than just what would have been in conflict. So when she was out of the room not listening to the conversation, they spoke about more than just the conflict issue.
Oh, so she missed some of the information or some of the.
I think that's it. She missed some of the of the council meeting.
I don't think you can do anything about that now. What's done is done. Unfortunately, the council and administration maybe just forgot to go out the door and call you back in because that matter was finished being discussed. So hopefully that won't happen again. I don't know if you can do anything about that now, but let's just hope it doesn't happen again. Make it known to the other council members that you stepped out for a conflict of interest only on one particular matter, and ask to be made aware of when that matter is completed, when the discussion is completed, so that they can call you back in.
Okay, thanks, Judy. Next question is from Helen. If discussion is happening regarding the administrator, should the administrator leave? And or can council request that the administrator leave?
So if you're going to go into a discussion about the administrator, and I'm assuming you're meaning perhaps a performance evaluation or something about their work, council first of all should make a motion to go into a closed session. That's dealing with a human resource issue, and those type of issues should be dealt with in a closed session. And council can decide who should be in that closed session. Of course, in that particular instance, you probably want all of the council involved, but you can ask the administrator to leave that closed session and not participate. Now, again, when you're finished, you come out of a closed session, you make a resolution to resume the regular session of council, have the administrator come back and carry on.
Okay, thank you for that, Judy. The next question is, can you repeat the 5 steps you mentioned on conflict of interest? Declare, disclose, ...
Okay.
And leave. I guess she's just wondering what the others are.
So remember the word darl or dadarl, double D at the beginning. D for disclose. Declare. The first one's declare. The second D,
declare, disclose, yeah.
Then A for abstain, which is abstain from voting. The next one is R for refrain. And the last is the letter L for leave, just leave the council chambers. I guess if you get a copy of the presentation later, if it's going to be emailed to you, you'll be able to see that slide as well.
Okay, thank you. Let's see. Okay, here's our next question from Stephanie. On the public disclosure statement, can you confirm who qualifies as a family member? A spouse and dependent children or more? Question mark.
Our legislation right now talks about spouse and dependent children. That doesn't mean that you may not have a conflict of interest for other people that are closely connected to you. So on the public disclosure statement, just put your family and dependent children, spouses. But if a matter comes up before council that might involve, let's say, your grown son who farms with you, then you'll probably want to disclose a conflict of interest in that type of a matter as well.
Okay, thank you for that. Let's see. Wanda Jones asks, are minutes kept during a closed session and who records them?
No, there are no minutes. No decisions can be made in a closed session. No motions, no resolutions. It's only discussion. Everything that's discussed in a closed meeting is confidential. If a decision is required as a result of that discussion, you must come out of the closed session, resume your regular council meeting session, and that's where you can make a resolution about any decision that is needed as a result of that closed session meeting.
Okay, thank you. Next question comes from Dawn. Is it too late to leave in the case of a conflict of interest after debate and a motion is made?
Okay, can you repeat that, please?
Certainly. Is it too late to leave in the case of a conflict of interest after debate and a motion is made?
Well, it's probably too late to leave because that matter is done. A decision has been made, but you should definitely still disclose a conflict of interest that you may have in it. Now, again, it's unfortunate that the conflict wouldn't have been made earlier. I guess there's a risk there that it wasn't completed earlier. I don't know what may become of that if somebody were to challenge it, but after a decision is made, there's not much you can do other than still make the declaration about the conflict of interest so that it's recorded in the minutes. If it happens to come up again in the future, you'll probably remember the second time around that a conflict of interest should have been declared earlier before a discussion even begins.
Okay. Thank you, Linda. Or Linda, Judy. I'm reading Linda's name on this thing. Sorry about that. Linda wants to know if she can get a copy of this. And yes, we have explained, I think Adam's explained that, but Linda, if you have any trouble, get back to us and we can provide you a copy. We have a question from Dana. Constituents contacts in the RM. Is it okay for all councillors to have a list of names and contact information so you know who the neighbors and or others are when needing to contact people to resolve an issue or just follow up? Is there any issues with freedom of information on this type of information? So having contact information for constituents.
Yeah, I think that actually would be an issue under the privacy legislation. First of all, I can't really see the need for every council member to have names and contact information for their ratepayers. If there's something that needs to be done or if there's contact information, no, if you need to contact those ratepayers about any matter, why not go through your administrator? The administrator does have contact information, probably not for everybody. I know when I was an administrator, I had a list of names of all my ratepayers, but I didn't necessarily have their phone numbers. People have the right to not provide that to you. The reason a municipal office even has personal information such as phone numbers and addresses is really for the purpose of doing municipal business. And if it's going to be used for anything else at all, that could be a breach of privacy. Now, that being said, in LaFoIP, the privacy legislation, it does say that if a municipality wishes to share personal contact information with anybody outside the municipal office, you could do so only with the consent of those individuals. So that would mean contacting all of your ratepayers and asking if they give consent to their personal information, which is addresses and phone numbers, to be given to council members. But I really think that it's not necessary. Just go through your administrator. If you need to contact a ratepayer, that also sounds like an operational matter that a council member doesn't need to be involved in. That's up to your staff to do the contacting. So have the administrator phone that individual to relay whatever message it is that you want to get to them.
Thanks, Judy. That is an interesting topic for sure. And I think it's important for people to understand that.
Yeah.
That's great. Bridget McDonald asks this question. Are there any instances where there is a conflict of interest declared that the councillor does not have to leave the council meeting?
Yes, there is. Now, I wish I had the legislation directly in front of me, but if a council member is wanting to discuss a matter that is not only involving him, or he would like to address council on a matter that does involve him personally, but he wants to address council like any ratepayer would, he would still disclose that. He would have the ability to address council, but then he has to step away for the discussion and the decision making. He can't participate in that part of it. So I wish I had that just handy here. Whoever's asking that question, please contact our office and we'll go through that maybe in greater detail. We'll find that part of the legislation and talk about it.
Okay, thanks, Judy. The next question comes from Helen. We as councillors are tasked to contact our ratepayers for snow ridging. Is this a task that should be done by the administrator instead, as contact information is given out to councillors based on each division?
Well, I believe that that's an operational matter, snow ridging, and that it should go through the office and let your staff contact those individuals. Now, again, like I said before, unless those individuals have specifically given you their consent for their phone numbers to be used by council members.
Okay, we are done our list of questions on the screen. Does anybody else have any questions they would like to ask of Judy? Will we have her undivided attention here? You'll notice that she offered, if people need follow-up, to certainly, call if you need more information. Oh, Roxanne has provided us a question here now. So further to that question about a councillor staying in a council meeting when a conflict is noted, please clarify. Example, a councillor has a construction company and has bid on a project. Other contractors have also bid. Can they all stay in the meeting?
I'm going to ask you to read it again, Laurel.
Sure. So basically, further to the question about a councillor staying in a council meeting when there's a conflict noted. So the example that she has, a councillor has a construction company and has bid on a project. Other contractors have also bid. Can they all stay in the meeting?
So that's a difficult one to answer. First of all, if they have a construction company, that company will have been noted on their public disclosure statement that either they work for that company or they own that company. So anything that's on your public disclosure statement, anything that is listed there, is automatically a conflict of interest. Okay? So if it's on your public disclosure statement and anything comes up before council dealing with that particular company, you have a duty to disclose your conflict of interest for that. Now, I guess I'm thinking to put a little bit of trust in your fellow council members. They can make a decision, one decision without you. It's going to be far better for you and the public trust if you do not sit there, participate, nod your head, make any other bodily gestures when there's a discussion going on about your company. Get out of the room. You've got it on your public disclosure statement. Declare and get out of the room.
Okay, thanks, Judy, for that. The next question I have is from Dana. What are the restrictions on municipal reserve spaces? Can it be used like a back alley access in the cities, or is this just up to the individual RM to decide on?
Okay, actually I cannot answer that, but we have another branch in our ministry that certainly can. That is regulated by the Planning and Development Act, and we have a community planning branch, and they're the experts with anything to do with zoning and the Planning and Development Act. So please call that particular branch. I don't have their number handy, but if you call our office, which I put up on the screen earlier, 787-2680, we can look up actually a community planner that looks after your specific area, because the entire province is divided into regions for different community planners. There's an office in Saskatoon and also an office here in Regina. So we can find out for you who your particular community planner is and can certainly answer questions to do with municipal reserves.
Okay, thank you for that, Judy. We have a question from Stephanie. Can a town and RM that share office staff use the same person as administrator? What are the qualifications needed for an administrator?
Certainly, they can use the same administrator. In fact, there are many municipal offices out in our province right now. Trying to remember the numbers, I feel that there could be as many as 70, 80, 90 municipal offices out there that are shared. They share an office and they share administrators. When I was an administrator myself, I was an administrator for both an RM and a village at the same time. We shared an office and everything else was done separately. We had an office assistant who was the office assistant for both municipalities as well. Now, when it comes to the qualifications, I would recommend contacting the Rural Board of Examiners. They can explain to you exactly what the qualifications are. But in a nutshell, there is a series of classes that need to be taken through the University of Regina. People that have degrees in certain disciplines, for example, business administration, I believe they also qualify as having the educational requirement for qualifications of administrators. In addition to educational requirements, and I didn't list all of them, so please, again, contact the Rural Board of Examiners to find out more about that. But before becoming certified or qualified, an administrator has to have, I believe it's 1,800 hours of experience in a municipal office under the mentorship of an administrator with, it's a little bit different. On the rural side, they call it an A certificate, and on the urban side, a advanced certificate.
Okay, thank you, Judy. Next question is from Dawn. Is being an employee of a company similar to having a controlling interest or being an owner of a company with regards to conflict of interest like you described?
I don't know that. I suppose when you registered your corporation, your company, you would have had to list on there who the board of directors consists of. You would list everybody. So that would state who's involved in the directorship, at least, of the company. On your public disclosure statement, you may have to list any shares or business holdings that you have. So, sorry, I don't know anything more than that when it comes to those particular details.
Okay, thank you. Next question is from James. So are there limits on where and how a counselor can research a topic? So he just makes a comment that it's impossible to make an informed decision if you are limited where you can gain information.
So maybe you want to stall making a decision. There's nothing wrong with that. You know, it's better to make an informed decision after you have done all of your research to get as much information as possible. So if it's possible at all to stall making that decision, put it off till the next month's meeting. And in the meantime, start doing the research. Have your administrator start doing the research and look for as much as you can. Now, if you don't have the in-house expertise in some matters to find all the information that you need, there's probably a lot of experts out there that you could hire, like consultants, perhaps lawyers. I guess it really depends on what the matter involves. But if at all possible, don't make a decision until you have the ability to make one that's informed.
Okay, thank you, Judy. Again, I think we are cleaned up on questions here. I don't see any others right now. lots of questions about how to download the file, but Adam's got that under control. And Amy, thank you guys. Oh, wait, we have another question from Dana. At what point does a subdivision go from recreational to residential? Do you need a minimum percentage, such as 50%?
Okay, again, that is a community planning question. Also look at your zoning bylaw. If you have a zoning, I'm sure you would have a zoning bylaw just because of the type of question that you're asking. So take a look at your zoning bylaw first. You may be able to determine that yourself. Otherwise, if you want to make changes to your zoning bylaw that, because maybe it doesn't right now allow for what you're wanting, then there is certainly the ability to amend your zoning bylaw. So again, contact your community planning that works for our planning branch, our community planning branch. They are the experts on the Planning and Development Act and will be able to help you.
Okay, thanks again, Judy. Any further questions from our participants for Judy today? Takes us to the end of the ones I have here.
So I'll just take a minute to say that, sometimes typing in a question and answering it may not give you the complete answer that you were looking for. And sometimes it's easier just to have a conversation directly. So by all means, call our office and then we can ask you additional questions to make sure that we understand your questions properly. So feel free to call us.
Thank you, Judy. And just so you know, you did get a few thank yous for your answers to the questions in the chat. So people are appreciating the answers you're giving, and I'm sure they'll reach out to you to follow up, which is great. So thank you so much for the informative presentation. I think we'll, oh, I have one more question. Would you like to take one more?
Sure, no problem.
Look at this. People are, Jessica Davis, any advice on how to get counselors to participate in webinars like this?
Tie them to the chair and put it up on your screen, make them watch it. There's no way. There's no way that you can make them do it. All you can do is encourage it. I don't know if your council could maybe pass a bylaw encouraging all newly elected council members or even those that have been around for a long time, encourage them to participate in some sort of training and webinars. Boy, there's a lot of them out there. Not only the ones that the province puts on, but there are webinars that your association puts on. There are webinars put on by the administrator associations, and there are a host of webinars put on by private consulting firms. And like anything else, how can you go wrong in taking more education and learning more so that you can do the best job that you can do as a council member? So all I can say is encourage it as much as you possibly can. Maybe the right person doing the encouragement will be able to convince other council members to do it. Maybe suggest doing it as an entire group instead of individually. Sometimes that makes people more interested in doing it if it's doing it with somebody else.
Great, that's a really good suggestion. We have one more question from Kirk. What are the responsibilities for conflict of interest on committee members who may not be a council member?
All right, so you may have to have a look at your council procedures bylaw. There's a whole section in there that talks about committees, and it may also address conflict of interest as well. If it doesn't, you can certainly put into your council procedures bylaw that conflict of interest pertains to committee members. Be careful. Some committees are formed by more than one municipality. So it could be a committee that consists of members from even a few municipalities, 2 or 3 municipalities perhaps. So always a good idea to have the same conflict of interest rules apply to committees as well. How can it be a bad thing if you have people declare and disclose their conflict of interest? Then they're just going to be able to do a better job being a committee member.
Okay, thank you for that again, Judy. And now we are out of questions again, so I think it's probably tapering off here. So again, once again, I appreciate all that you've provided today, Judy. So thank you. And those that need to follow up directly with advisory services, please go ahead and do that. I think we can close this webinar if everyone's good with that.
Thank you,
Okay.
everybody.
Thank you.